Mr. Speaker, sir, this issue, an issue which is time and again taken up by many of us, we have discussed this issue not just once, not just twice, outside the House, mostly. In fact, Mr. Speaker, sir, earlier also I made a submission in this August House that whenever any item for discussion, particularly specific to this reservation policy, we have tried to engage with all our distinguished colleagues and members of this August House, even outside the House, so that we discuss this issue as less as possible, or rather we avoid discussing this. It is only because of the very sensitive nature of this particular issue and the whole issue of emotions versus empathy. And it has been not only my effort, but it was the collective effort of successive governments. Now, for whatever reasons, somehow this matter has, I think sequelae, if we look at the genesis of the current discussion, is because of the Honorable Court, the judiciary taking, so much cognizance of one very important aspect of the provision in the policy itself, and also the provision which provided that space to be incorporated in the policy based on the mandate of the Constitution. Mr. Speaker, sir, why I have said that this particular issue be discussed outside the House at a level which can actually confine our discussion and debate within the four walls was because of the way we need to think as lawmakers. Because there are certain provisions in the Constitution, the mandate of which we utilize for making laws. In certain cases, it's a very, very tight rope walking exercise. I, Mr. Speaker, sir, would like to place on record my sincere gratitude and thanks to our forefathers who have definitely done their tightrope walking together after the creation of this beautiful state of ours, which we have inherited. And the policy itself indicates the sense of oneness of our leaders at that point of time. Because at that point of time also, if we go by the statistics, the similar statistics exist. Therefore, the reflection of the kind of prevailing mindset and the thought process of our leaders of that time, I think we must understand the wisdom which guided them to come together. And with that sense of oneness, three important sisters from the same family, the Kazi, the Jaintias, the Garos. And they did not even forget other tribals. And the space again for all those meritorious from amongst our communities and also other people who belong to other communities, that 15% open category in order of merit. Now, if we go by data and statistics, then it will not end. But the spirit of that collective and unanimous decision, which has given us this very powerful legislative mandate to ensure that our own children are in a position to be part of the system which is vested on the state. The employees of government departments are the people who utilize the repository of state power in the best interest of the people and the state as a whole. Today we have come a long way, Mr. Speaker, sir. Very, very long way. Yes, even when we were confronted with this demand for number of times, it's not just once, as I have said, too frequent. But then I think we also have to look at certain aspects as a lawmaker. As a lawmaker, as I have said, tightrope walking is a difficult proposition always. When we talk about this provision of Article 16, Clause 4, and the other provisions which are part of the Article 16, Clause 4, Clause 4b in our case, 4b. Now here, precisely because of this provision of the Constitution, only we can understand as lawmakers with the possible interpretation of the various provisions of the Constitution thereof, that the judiciary has taken cognizance of certain policy decisions, certain implementation of this policy. But there's a big but. Now, before I go to this big but, this particular clause under Article 60 of the Constitution of India should be read along with other clause. The Clause 1, Clause 2, it cannot be read and interpreted in isolation. That is how, as a lawmaker, we have to look at it. And that is how every law that has been enacted as per the mandate of the Constitution, if we go by various ruling of the Honorable Supreme Court, we see that this integration while interpreting the provision of any provision in the Constitution is not taken in silo. It is all interconnected. Each and every fundamental right is again interconnected, Mr. Speaker, sir. That's the reason why we have always said it's a tightrope walking, and if we don't walk it with a proper balance, we can slip. That is the reason. We cannot take judiciary for granted, nor can anybody should take legislature for granted, nor can anybody take the parliament for granted, Mr. Speaker, sir. That is how, as lawmakers, we have to navigate through this very challenging terrain of taking decision and giving mandate through legislation and lawmaking. Mr. Speaker, sir, here why I'm saying there is a big but. While the court took cognizance of this issue, there was no space for the for the judiciary to intervene. If we would have defended whatever employment, whatever appointments were made in the past as per the mandate of the policy. Now, I will only refer to one thing. Yeah,
This is a short duration discussion, so I think
it is, but then it is a very important topic, Mr. Speaker, sir. It is a topic which is confronting us. It is an issue, it is a matter which is confronting everybody. And we're going to have problem unless we show that sensitivity to speak on this issue. In fact, I will request even the members from the August House, from the Treasury benches to speak. Yes, people want us to speak. And here, I would like to refer to this particular para of the resolution as per the notification, reference personal 222/71/138, the government of Meghalaya declared its reservation policy for reservation of posts in favor of ST and SC. According to the said policy, the following reservation. This is the notification dated 12th January 1972, which is also compiled and reflected in the expert committee report for reference. All the notifications have been duly incorporated, and there are so many annexes. In fact, it is not possible to complete exhaustive study of the whole report within this short period of time, though we have looked at only the recommendation, the operational part of the recommendation. But there are many other collaborated, closely related decisions of judiciary. Now here, the paragraph says, if sufficient number of suitable candidates for filling up the reserved vacancies is not available from the respective classes in any particular year, then such vacancies will be available to others. But the deficiency in the number of scheduled tribes and scheduled castes will be carried forward to the next recruitment year and made good in the recruitment of that year, provided, this proviso is very crucial, provided that the reservation on account of the deficiency shall not be carried forward for more than 1 year. That was there. That's why we did not carry beyond 1 year. The only problem was that even though we carried it forward to do good to the vacancy which was otherwise not filled up to by the applicants belonging to that particular category for which the reservation was meant for, what happened was that within 1 year, it could not be done. That is the only purpose. I mean, that is the only background of the reason. Because subsequently, because this proviso says that these shall not be carried forward for more than 1 year. So where is the deficiency in respect of the implementation of this reservation policy by the government? There is no deficiency. It should have been very effectively defended in the court. We have faith, Mr. Speaker, sir. There is no question of any backlog of this carried over, and this roster system is only for 1 year. It cannot be carried for more than 1 year, till now, because we have not amended this, even now. So where is the question of that backlog and the apprehension thereof? Mr. Speaker, sir, these things again is amended as per the clause 4B of the Article 16. It's amended based on that. Therefore, the Constitution does not say how many years the vacancy which otherwise cannot be filled up by the members belonging to that particular category for whom the reservation was meant for while filling up the vacancy. Therefore, the resolution is in sync with the mandate of the Constitution. Therefore, I say that wisdom actually, out of collective engagement of our forefathers, of the framers of this initial law, I must put on record my sincere appreciation for this wisdom, the collective wisdom. It's not a wisdom of an individual. Therefore, then another part, let us be little blunt and be realistic. Look at every result of the MCS, civil service exams. Look at. We must appreciate and take pride in the competence of our youth. Top that in order of merit, mostly by our youth from belonging to Khasi, Jaintia, and Garo. That means what? That means we have children and youth who can compete with these non-tribals, and then you don't see any non-tribals in the MCS list. Do we see? Let us be frank and blunt. That means that 15%, which is open for everyone to appear for job with the sense of competence and the resolve to compete, we must commend the competence, the spirit of competitiveness of our youth for filling up that vacancy which is covered under that 15% open category. Every interview, whether it is in DSC, whether it is under MPSC, whether it is for civil service, whether it is even for corporate, I have one result of the MECL for recruitment of those technical manpower, all. We must really give the kind of accolades to the sense of competitiveness of our youth. Though we have the reservation, some of them are not depending on the reservation. They are competing and they are actually coming out with flying colors. Therefore, this particular so-called roster system is only for 1 year. There cannot be any backlog. This is the interpretation in as far as this provision is concerned. And collaborate with the clause. Yes. 4B of the Article 16 of the Constitution of India, I would like to read. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation met under Clause 4 or Clause 4A. As a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of course, here it is reference of 50%, reservation on total number of vacancies of that year. So, the Clause 4B of the Article 16 of the Constitution of India says that the vacancies in any succeeding year or years, it doesn't say years, it's a year. So, based on that, probably the collective wisdom of our then leaders, our forefathers. So, therefore, Mr. Speaker, sir, I would like to urge through you, the government, we can have a continuous discussion and understand how to navigate through this challenging time. We know the aspirations of our youth. We know the aspirations today. These aspirational dreams to be part of the governance, because we have today highly educated youth. Why this issue becomes so sensitive and emotive is because we are also failing to create jobs. If there are abundance of spaces available for the job seekers, this issue will get diluted easily. Therefore, the government of the day, as I have been saying, let us look at all the vacancies and create more jobs. Yes, we talk about other jobs, self-employment, entrepreneurship, becoming an artist. Not everybody is going to be capable of doing that. So therefore, the job that should be created for all categories of people, all categories of those job aspirants, will definitely create an enabling environment to once again create that sense of sufficiency and infuse a sense of oneness and spirit of oneness. Mr. Speaker, sir, I think it is necessary for us to create that spirit of oneness with the whole spirit of empathy, love, compassion, and mutual trust and mutual respect. I thank the honorable member who have brought this important matter for discussion under this short duration notice. And I do agree that he, as a leader of this August House, one very important new political party, has appropriately taken up this issue. But there are also challenges, as I've said, as lawmakers, which we must comprehend and understand, because this kind of lawmaking is a tightrope walking. Yes, we have all the data and documents, including the interventions and observations of the judiciary. So with these few words, I would like to submit before the August House, through you, Mr. Speaker, sir, that the Honorable Chief Minister may again call all of us, have a discussion internally, and that is best done in the office chamber than in this August House. And we, I think, as leaders collectively can really lead our children and our grandchildren in the right direction as one family, children of one mother. Thank you, Mr. Speaker, sir.
Yes.